Everyone, welcome to the first policy committee meeting of the school year. Our next meeting will be on Friday, October 22nd at 8:30. We have a lot of policies to review this morning. I think we have 9 of them. I will pass it off to Marge to get us started and we can dive on in.
Thank you. So the green cleaning policy, we're adding back the language that expired on June 30th. This just clarifies that there are certain cleaning solutions that are approved by the federal government that schools may use. Whatever.
Yeah, okay. I think it's easier if we go one by one. Okay, let's start with the green cleaning program. My only question in reading this is adding in the section saying sort of everything that is federally approved we can use. Is calling it a green cleaning program an appropriate title if we're gonna?
It still complies with the Connecticut law about
Okay,
green cleaning.
so it
program.
does. So where possible, we use green products, but in certain circumstances, COVID, we're using products that may be not in our normal repertoire of green products.
We've actually been using these products all along, but with heightened awareness, because it's legal, but with heightened awareness over COVID, the Shipman and Goodwin felt it would make it clear to the public that these cleaning solutions are also available to use.
Oh, great. Okay. Any other questions from the public? I don't know if Dave Brown is on Zoom. If you are, Dave, can you just let us know in case you have any questions?
He is not on.
Okay, I don't see Dave at the moment. Okay. Moving on. I think it's use of school facilities.
Use of school facilities, we're also adding back the language that expired on June 30th, that anyone who uses the facilities has to comply with all health and safety protocols that are currently in place.
Okay. The one question I had was actually I have a couple questions on, this wasn't a red line, but in reading it, it says applications for the use of facilities related to school-based athletics shall be submitted in accordance with the administrative regulations to the director of athletics. I thought requests for fields went through Mike Lynch's secretary. Am I wrong on that?
They're electronic, so both of them have access to it, but I can.
So I think we
clarify.
should just update that because, yeah, so I would just make that change. And then we did have a comment from the public on the order of priority. And Marge, if you could just speak to the fact the Darien YMCA contractual arrangements are kind of low down on the list. Could the 1 through 4 possibly bump the Y from the contract?
So I did speak to Rich Rudel about the new contract that we're negotiating. I'm not sure whether it's been signed, but we should put 4 and 5 on the same line. Okay. And it hasn't been a problem that the Y would bump the town. They're usually asking for 2 different things, but we should put them on the same line.
Mrs. Stein.
Yes.
Do we want to make it as specific as the Darien YMCA? I mean, what if we contracted with other individuals and we have a standing contract in place? We couldn't bump them. So I'm just wondering, do we want that language to say, you know, any organizations for which we've entered into a contract with? The YMCA just seems very specific. Maybe if we could just take a look at that.
But even for
No.
the future.
Yeah, that's, I mean, the policy has to stand the test of time. So if we had a contract with an organization, it couldn't get bumped by something else if we've legally signed the contract. So maybe just look at, do we want to be that specific or do we want broader language? If we've entered into a contract for the school year, we honor our obligations as the length of the contract.
I mean, I guess from the administration's point of view, philosophically, do you want the Y and the town to be on a separate line together? Or would you, I mean, I'm not sure that that's a policy as much as a philosophical thing of where we rank people.
So I would just say, let's look at the policy implications of saying specifically that we'll honor one organization, but maybe not others. And then philosophically, the board could have a discussion whether they want to enumerate the YMCA. But if we were to sign a contract in the future with anyone,
That would supersede.
that would supersede it because we'd have a legal obligation.
Oh, your microphone.
Is that right? Was that your question, Marge? Were you asking about how we're seeing the town vis-a-vis other organizations? Because I
The
agree with your
town and
point,
the-
Tara.
Right, the town and the why, because Tara's right. Number 6 is very broad about activities of nonprofit organizations operating within the town. So that would cover some of the other organizations that we deal with. And, I'm fine with making it more general as long as the board wants to treat the why that way. It's not,
I can't hear you very well.
I'm
Marge.
sorry. I'm fine to make the reference to the why more general, to say other organizations with whom we contract.
Okay,
I'm not, I don't know, we have to look at whether that brings in all of number 6. Is number 6 a Darien after school?
right.
So my question is, what I don't want to do is end up in a conundrum where we have a signed contract with an organization. So we have entered into an agreement with them, but yet our policy allows the things above it to bump them. Or I want to be aware that if we have a signed contract, we are aware that things can bump them. So I'm just asking whether we want to be as specific to the why, or we want to say organizations that we contract with. Activities of nonprofit organizations are typically organizations that approach us for use of facilities. They're not necessarily people we're in a contract with. So now that we've changed our behavior with the why, I understand why we specified here. I'm just saying, do we want to be broader in case in the future we have to do that with anybody else? So if the why disappeared, and I am not saying
Right.
that, but let's just imagine a world when there's no why, and all of a sudden it was Chelsea Piers. Would we be writing Chelsea Piers into our policy? I don't know that we always want to have the vendor in the policy. Just something to think about.
No, agree. And I think going back, just looking at currently the operational way, the implications currently the way it is will be helpful to just to inform that.
But does that answer your question, Marge, about how to evaluate number 6?
So I think that Dr. Adley's right. We'll go back and check with Rich Rudel and his assistant, and then we'll get back to you to see if it would affect anyone. I
Okay.
think that's the best way.
Thank you.
I see Dave has joined us. Dave, if you have any questions on this policy, please let us know. Okay. Moving on to visitors.
Oh, sorry about that. I couldn't talk for a
Hi,
minute.
Dave.
Sorry about that. Having some technical trouble. Thank you. I just had a question broadly to Tara's question. I don't think policy is going to control contracting. Contracting is going to be controlled by contract law. So I don't really see how this is at all as an interplay with policy, because that we can have a policy that we do X with a contract, but the law is going to tell us what we do. So I don't see why that is germane.
Great, let's go back and figure it
Well,
out.
why don't we have Marge talk to Gwen and figure that out before the next meeting? Okay?
That makes sense to me. Thank you.
Okay, awesome. Okay, moving on to visitors.
So both visitors and school volunteers, 1225 and 1250, we've added back the language that expired, that people who are in the buildings must comply with health and safety protocols. In addition, in the regulations for the school volunteers, student interns, and other non-employees, the group 2 volunteers, those volunteers who are alone with students or who go on overnight field trips, we require them to be fingerprinted. Shipman is suggesting that we do this every 5 years instead of just once.
I didn't really have any questions on it, other than a question was raised by the public about contractors. And I believe contractors are governed separately from visitors in school buildings, and we have the requirements for
Yes.
them on school grounds separately.
Yep.
Does anyone have any other questions? This is a couple policies. Dave, do you have any questions?
No questions. Thanks, Katie.
Moving on to student discipline.
Again, the provision that expired, which allowed for not only virtual hearings on expulsions and suspensions, but makes it clear that misbehavior on electronic platforms and on our software is also subject to discipline.
I'm just going through to make sure I didn't have any notes on this. I just had a one, unfortunately, it's not numbered. On under procedures governing expulsion hearing, bullet C, I'll just give it to you, Marge. There's just a typo. It's virtual. Instead of virtually, it has a T at the end. So I'll just give this to you.
Okay, thanks.
But I don't, these didn't come up with numbers on mine. You see that, Alan?
Yeah, I see where that's, I'm just looking at that.
And then, oh, it looks like it was the former page
Oh, yes, you got it.
17. Under hearing procedures. The hearing may be conducted virtually via video. It's the red line portion, via video conference at the direction of the board. In the event school buildings are closed to students or individuals are provided limited access to school buildings due to a serious health emergency. Any virtual hearing must provide the student the due process rights. My one question is, can a student or family request a virtual hearing, or is it only at the discretion of the administration?
I can check, but I believe it's the discretion of the administration, but they could request. right?
Okay,
Yeah, I think we would try and do, if at all possible, do that in person, but the intent of this obviously is if we're out for some reason, health wise or otherwise, it makes sense, so. I think we would try, but that this gives you the coverage of provision that we can't.
sorry, this was a long. I think those were all my questions. Does anyone else have questions?
Nope.
No,
I do on,
okay.
let's see, I'm
See,
on
you're on the, yes.
section 3, number 6. We have any act of harassment and we're pretty explicit. Although, there's a caveat, any other characteristic, but do we want to add political party to that? It seems like there's more and more discussion about people's appeals.
Jill, now I'm having trouble hearing you. And
I'm sorry.
a little
I'll try
trouble.
harder.
Can you read the line you're
Following.
referencing?
I will. It says any act of harassment based on an individual's sex, sexual orientation, race, color, religion, disability, national origin, ancestry, gender identity or expression, marital status, age, pregnancy, veteran status, or any other characteristic protected by law. And so it looks like we're trying to be as inclusive as possible.
I think those are legal protected classes. Political parties aren't legal protected classes, so I would hate to start delving.
I'm not sure that the enumerated ones there are all protected legal classes. So that would be the first question. I agree, because I think there are things that are not in that list already.
Do you want to just ask one about
Yeah,
that?
we can get.
I will, but those are protected by Connecticut. They may
Yeah.
not be protected as the, lawyers in us would say as the Supreme Court, but I will confirm, because in the memo that Shipman sent with those changes, it said that, due to changes in the Connecticut law.
Sorry, the
Yeah,
last.
the
Changes in
citations or
Connecticut law.
follow-up would be great. Thank you.
Wait, we have 3 people
Yeah.
talking at once. So Jill, you had a question?
I didn't hear the last sentence, Mark.
Those are due to changes in the Connecticut law, and the change in citations are at the end of the policy.
Okay,
Yes.
thank you.
Thank you.
My understanding of what was enumerated is, as Marge said, what Connecticut state law identified as the classes. So I would be comfortable sticking with that, or else I think we would open it up to a host of categories.
So the political harassment because of political party might actually fall under the next policy of bullying.
Okay.
Moving on to the bullying prevention and intervention policy.
Right, so the changes to this policy reflect some substantial changes that the legislature made to the bullying statute. So the definition has changed, and it's going to be interesting to see because it says individual instead of student. It doesn't necessarily have to be someone in the district. But our administrators have already been trained in the new statute. That was part of our retreat at the beginning of the year. It also goes on to just codify some of the things that the district needs to do, like post the training materials and provide plain language explanations to families and staff. And also it adds some additional people who need to sit on the school safe and district school safe climate committees.
Okay, I have a couple things. Some are just some grammatical, just on the first page. For purposes of this policy, bullying, the way it reads, I think you need to put means back in because it's a definition under it.
Yes.
Yep.
And then one of the questions I have about bullying in the definition, we had always heard it was a sort of a systematic event. Now it can be a one-off event. I
Yeah,
think that's
yes.
a very big
Yes.
change.
That's correct.
And I think we need to, once we implement this policy, make particularly parents aware of it as well, because I know that there is the threshold has changed. And I think our district needs to be aware what the threshold on bullying is here. Okay, wait, I have a few, sorry. Okay. On page 5, as required by state law, the board, after consultation with the Connecticut Department of Education and Social Emotional Learning, shall provide the training. What is that consultation? Is it annual? Have we done it? What does that mean exactly?
Well, my understanding is that the School Climate Advisory Collaborative hasn't developed the training materials yet. So we're waiting for those.
You're waiting.
Yeah,
Okay.
that's correct. Yep.
Yeah, perfect. And then when we're talking about the makeup, the new makeup of the members, prior to this, we didn't have a parent or a student on the Safe School Climate Committee. Is that correct?
You know what, Dr. Riley, I have to look to you for that.
No, my understanding is we did.
Oh, we have.
Yes, my understanding we did.
Okay, because the one thing that sticks out to me is,
Which page is that, Katie?
sorry, on page 11. In the case of a committee for high school, at least one student enrolled at such high school who is selected by the students of such school in a manner determined by the school principal. My fear is we're picking students who are going to sit on this committee and review bullying complaints.
So parents or students cannot review individual cases of bullying. They can,
I don't believe that's what it says. Any guardian or parent serving as a member of the committee shall not participate in any activities which may compromise.
so
They won't participate. Okay, good. Thank you. I
they
misread it.
can, they can, in generalities, if this is a pattern of something, or this is this is how many cases we had or something, but they cannot.
So they will not be reviewing any
No.
bullying complaints. Thank you. Okay, I'm glad that's clear. So still on 5, development of and review of the Safe School Climate Act. I think we're missing after the red line, or it's sort of purple, after bullet 4, we go back to bullet 1, which seems to be a different paragraph about like process versus makeup of the committee.
Yep, I'll find.
So I
find
think
that
we just
language.
have to change.
You get that one, Marge?
Here, you see it here.
I have
So
it.
Just,
Yeah, good, thank you.
hold on. I think that's all I have. Does anyone else have questions on this?
Well, the same one that I had before then, because this one is more general. It's
Katie, I just had a quick question in terms of moving this forward before we have a chance to review the training materials. Is that seem awkward to anyone else, or are we compelled we have to take action now?
Right.
It doesn't preclude us being responsible legally to exercise this. The fact that the state hasn't delivered stuff is not going to give us a dispensation from actually implement what we have to implement.
Right. And actually, when Dr. Adley got here, I'm losing track of how many years ago it was, we have implemented our own bullying prevention training module, which has been vetted for Connecticut law. We get it through ProTax, which used to be our teacher evaluation plan. And every single employee in the district signs off every year that they've taken that training. So the materials will come from the state. They'll be required, but right now we're already doing something that is consistent with the law.
Got it. So there wouldn't be any inconsistencies with what the state's new training will be and what we're doing, or we don't know we can't know the scope yet, but we think it should overlap for the most part.
There won't be anything that's inconsistent with the law because all of ProTrax's trainings are vetted by Connecticut attorneys.
Got it. Thank you.
Jill had a question.
So on page 5, that first purple paragraph where it does list, there are the categories we talked about earlier, but there's also an addition of socioeconomic status, academic status, physical appearance, or mental, physical, developmental, or sensory disability. So I would ask, do we add political affiliation there?
So my only question on that would be that technically children don't
Don't
have a
have one.
political affiliation until they're 18.
Right.
So I guess we could ask, are we looking at those 18-year-olds? But I would worry that we're starting to then label students much younger as having a political affiliation. And, myself, I went through different political affiliations all through my schooling. So I'm not sure it's where I would put into policy again. Doesn't mean that maybe as a district, we don't need to look at making sure everyone's opinions are welcome, but I'm not sure I'd be comfortable writing that into policy at this point.
Right, and this is just what the training has to cover, so I'm not sure that the state training will cover this anyway, but we'll definitely ask Shipman if there's a way to put it in somewhere.
Okay, thank you.
Any other questions, Dave? I'm going to assume no. Okay, moving on to student representatives on the Board of Education.
Yep, so this is a continuation of what was the superintendent's proposal to the board to consider this. So we've gone back, we've developed it into a policy, and we've also attached what the Darien High School's process would be. And certainly the board would want to approve the policy in general, but also to approve it's in here that you would approve the sort of process that they would undergo. So that's what we've done. Okay, so happy to entertain.
Awesome. I think it's really exciting. I have one question on the application and selection process under 5.
Yes.
Talking about to be considered eligible and remaining in the position, the student applicant must have no violations of the standard of behavior governing participation. In other areas, we make it, that's an annual thing. So if you had a violation in that academic year, you're not eligible. But if it was in the year prior, I know for captainships with sports, there've been a lot of questions around this. I think it should be consistent with other leadership positions in the district for students.
And that's the intent of this language, right?
Yeah, but the way I read it, it sort of says if you've ever had it, you're not eligible. I think you have to be more clear.
I think what Mrs. Stein is saying is that in other leadership positions in schools, like whether you're a captain or whether you're
Yes.
part of the student government, if you have a prior act that violated a code, it only stands against you for one academic year. It doesn't, and the way this is written, it stands against you if you're applying as a 10th grader, 9th, 10th, and 11th grade, it would still hold against you. So is that the intent? Or we have a higher bar here?
No, I think the intent, sorry.
Okay.
I think the intent is to be consistent, so we'll make it consistent then.
Okay. We probably need some consistency in that one all around, but it'd be good to have a policy one way, or to have a practice. And then if we're going to put it into policy, have it be consistent. I had a question, and I don't know if this is just, I imagine there's different models of how to do this. But when we said that you needed 30 signatures, I think it is, and 5 staff recommendations. Is that,
Yes.
I can't find it.
Yes,
I think it's number
it is in there.
4
It's-
on the
it's
selection
number
process.
number
Number
four.
4 on the, is that typical? Is that atypical? Again, I would just say that a student is applying at the end of their 10th grade, would they have 5 staff members to be recommended from at that point?
So typical, or I wouldn't say it's necessarily typical because honestly, across the state, people are all over the lot in this. It goes from very sort of casual appointment to a formal appointment and anything in between. This was one recommendation that came from the high school administration. I just haven't been a high school principal. If you're going to be a leader and moving from your 10th grade year, get into 11th, I think you could get. I mean, we're not talking about these people are writing 5 recommendations type thing. You're talking about 5 teachers, staff member. Probably could be coach or otherwise too. I think that's just sort of a test to the fact that they think you'd be a good candidate, right, and represent the student body. So it was a new one for me to see, right? At like 30 students and what, but okay.
Should we broaden it to faculty, coach, or advisor? That way it covers activities, athletics, other people in the building that may touch on, interact with the student in a certain capacity.
You certainly just change it to staff in general.
Would
I think that's what they mean, to be honest. I don't think that they're meant to be exclusive to other staff members.
And are you looking at high school staff?
That would be, I think that would be the.
I just think you should be specific.
Yeah, I think we should.
I mean, I do think we'll find some kids interested in this and they'll be asking these questions, so we should just be specific.
I would anticipate also people being interested in whether or not they could bring community recommendations. So, if you've done a lot in a certain community organization, I could anticipate people might ask. It may not be the intention, but I throw it out there as something we should be thinking about.
I don't think it is intention, Jill, but I'll be happy to discuss, but I honestly don't think that's the intention in this case.
Dave, do you have any questions on this policy?
Yeah, Katie, all good. Thank you.
I have one more, Katie.
Okay, Jill has one more question.
Yes, right. No, go ahead.
So I was curious if there was any thought given to what might happen if you have too many members of one family. So if I were still here in 5 years and I had a senior and a junior and was sitting at the board table, I would think that's probably not what we're looking to do. I hate to codify too much into policy, but it's a small town. So
No, that was one question that, thank you for bringing it up because I deliberately avoided it. Being conscious in terms of do we want to note that board members child can or cannot be on it. That is an open.
or 2 members of the same family.
As it's written now, it doesn't preclude it.
I
Which
believe we have a prior policy. We'll have to look if it's still in effect or been repealed, that you can't have 2 members of the same family sitting on the Board of Education. So if that's the case and the student member is sitting on the Board of Education, then that would be precluded to begin with.
if that's still the case, then that would. I'm assuming the board would still want to do that.
I think there are a lot of opportunities for leadership at the high school and other capacities. I think it could be perceived in a not favorable light for a board member's child to be that representative. We do have student council, other ways to lead within the building.
So do we want the policy to refer back to this other one? Because
We'll do a quick check of that. And
Yeah.
Clarify it one way or the other.
Yeah.
One of the questions, just an editorial comment, but may not be in keeping with it, but it will be the appointment timeframe. I was considering after the reorganization of the board, that the possible election time may be a good time, but I'll leave that up to the board can discuss that after when they want to start the process.
All right, so if that's kind of the goal, this is a first read. It would go to the board as a first read. It would come back to the board at the end of October. And when would it kind of be publicized to kids so they could get these applications done, reviewed? You're really not looking until I mean, do you think you could all get it done by November? Or are you looking January?
Yeah, the high school thinks that they can get it done by November. And I don't know that it needs to be a tremendous rush about it, but I would like the students participating as early as possible just to become accustomed with the issues, because we hit the platform running pretty quickly. But I don't want to force it either, right, in terms of if it doesn't feel right at the appointment time for one reason or another. The high school can do it, but it's running the process simultaneously until it's actually approved. So that's
The only question I have two questions on that. If starting this year for the 12th per year we put on, it's if they're applying early to college, this is something they would want on their college application, and it would probably be beyond that point, as most are due beginning of November. Then you run into the issue of next year, you're a senior, your current 11th grader senior. So then the term is only November till June. You're really going to lose kids over the summer, and then they've graduated and they're not part of the process in the fall of that next year. I personally think it should match the academic calendar for students, because if it's November to November, seniors have graduated.
Oh, no, they wouldn't be doing November to November. You'd just be doing November through the.
You just mean they would
Oh.
start a little late this year.
This year.
Yeah. But after that, it would be the
I
academic
would think
calendar.
if you could get it before the election this year, if there's,
So I think we need a policy in place before we can go out and market it,
yes,
right?
which
'Cause
will
that's what you would
be,
have to do to kids. So you're looking at a 2-meeting cycle. You're looking at a month from now, which is end of October. And then
Yes.
you actually need, if the high school thinks they can do it by November, for kids to know about it. So all kids have the opportunity to apply. That's really what we're looking for. If we want perspective at this board
Mhm.
table, we want all sorts of kids to be able to apply and know. So how you do that operationally is up to you all. But I would like to see, if we're moving forward with this be made available to all students and everyone have time to apply and get. I know it doesn't sound like a lot to get 5 signatures, but for some kids, that's a lot from teachers to build up. Now, maybe it'll help train them for college. There's all those benefits, but just think it through. I think the idea is to have kids at this table who have a perspective of what's going on that they could share with the board and the community.
Yeah.
And so we should make that a very open process.
Yeah, the worst thing you can do is rush something like this, because then you miss steps, and then it's not advertised properly, it's not inclusive, it's not closed properly, it's not. So I don't want to do that. So if we're going to wait, which you should probably do until it's actually approved, then the high school can do it in a thoughtful manner and bring it to the table as quickly as they
Yeah,
can.
whenever they're ready.
And I'm just looking through the Series 9100, and it may have been in an old policy, but since we batch repealed them all, I don't see anything on family members. So it looks like we need to take a look at that.
Certainly, from the point of view, if it's not there, I can certainly include it as one of the process criteria to be considered, at least for the student reps.
Dave, do you have any questions?
No, I just promised there would be no other family members from my family looking to join. We're safe from that department.
I couldn't
didn't hear that.
understand you. Sorry. Can you say it again?
I said I promise there's no additional family members on my side looking to join.
All
Safe from that department.
right, great. Well, moving on to the health and safety protocols related to the COVID-19 pandemic.
Right, Shipman and Goodwin is recommending that we reenact this policy that expired on June 30th. They feel it's important that the district be on notice that the administration will implement its health and safety protocols, which will then be embedded in some of the other policies that we are recommending to the board.
Okay, I didn't have any questions. I just had one little typo. I'll give it to Alan. Does anyone have any questions on this? Jill,
No.
Dave?
None for me, Katie. Thank you.
Okay, moving on to meeting conduct.
So the changes to the meeting conduct policy, in the first instance, give the board the maximum flexibility in how to run meetings until the executive orders start expiring, which I believe is April of 2022. The other change codifies that there should be no smoking in a Board of Education room where a meeting is held.
I don't think I have any questions on this policy.
I
Jill?
have one. So in a lot of the other policies, we kept in place some language around health provisions. So, when we did the 9110, for COVID, and we specifically added in any applicable laws, rules, executive orders, and our public health advisories pertaining to the COVID-19 pandemic. I know we wouldn't want to message that exactly because we don't, but I was just curious why this policy didn't maintain any reference to health and safety standards, whereas some of the other ones did.
And I'm not sure. The changes were just to allow the boards to have the electronic meetings. I think that the mandate says that you can do it now for whatever reason, but again, I can check with Shipman if you want to add something. I'm sorry, I can check with Shipman and Goodwin if you want to add something about health and safety protocols,
I just thought this was just simply procedural matters.
Yes.
No, I'm good. Dave?
No, I'm for leaving it as is, but you may as well investigate, but I think it's fine. It's drafted.
Dave, sorry. You go ahead. That was really, there's something on your line. We couldn't hear you. Can you say that again?
I think it's fine as drafted.
Fine.
Okay, good. Is there any public comment?
Good morning. If you would like to speak during public comment, please click the participants icon on the bottom of your Zoom screen. Next, click the raised hand option. The facilitator will identify you and please state your name and address. You will have up to 3 minutes to comment. There are no raised hands at this time.
Wonderful. Seeing no questions, I will call this meeting to an end with my gavel. Adjourned.
You need a motion.
Oh, I have to make a motion. Can I have
Just
a
a
motion?
motion to
Can I have a motion to adjourn? Jill, Tara, now I gavel.